And Ms. Dean, you're here representing yourself, correct?
Yes.
Okay. This is going to be case number 2022 PO 00228, Lacadia Dean versus Samantha Kyle. This is a Superior Court of of Clayton County. My name is Brad Gardner. I'm a magistrate judge in this court. I'm sitting by designation as a Superior Court judge. The cases on this calendar involves a petition for a restraining order under the Family Violence Act. The status of the case at this time is that a protective order has been issued upon the application of one party without notice to and without the presence of the other party. The purpose of the hearing today is to determine whether the protective order will be continued. That may happen in two ways. One, the first way is that both sides can consent or agree to a continuation of the protective order. Or two, if that does not occur, the petitioner will have the burden of proving by a preponderance of the evidence that the respondent has committed an act of family violence and that there is a reasonable likelihood of future acts of family violence. If the order is continued, it will stay in effect for 12 months and will automatically expire at that time. The order may be converted into a permanent order only upon the written motion of the petitioner following an additional hearing before the court. If the order is going to be continued today, there are a number of other issues that may need to be resolved based upon your particular circumstances, and we'll get into that as those matters arise. If you have shared use of any property with the other party, whether it is a residence, automobiles, furnishings, or anything else, the right to the temporary use and possession of the property will have to be decided. Okay. If you have incurred obligations to pay debts with the other party, the responsibility for making payments on those debts during the time the order is in effect must be decided. If both sides in your case would like, would like a chance to talk before we have a hearing to see whether you can resolve some or all of those issues, I will make that time available to you. However, no one is required to engage in settlement discussions. There are allegations of violence in these cases, and if you are not comfortable talking to the other side, you are not required to do so. So, Ms. Dean, do you believe it would be beneficial or fruitful to speak to Ms. Kyle and Mr. Bernstein about resolving this matter prior to a hearing? You're not required to do so.
No, I've attempted to contact Mr. Bernstein prior regarding issues prior to this point. So I feel like at this point, I have to protect myself.
Okay, no, the answer is no. If you are the person who filed the case and you no longer want a protective order, please make that announcement when your case is called. If an order is issued today and you perceive that there are problems with the order, either as to its terms or the failure of the other side to comply with the order, do not try to call me to speak about your case. I cannot speak with one side of any case without the presence of the other side. You can file a motion for contempt if you need a hearing. Now, Ms. Dean, this is your petition and you have the burden. So please tell me in as plain language as possible why you believe a family violence protective order should issue.
So there is a prior case of battery that was that resulted in an affidavit for nonviolent contact. However, and again, I've sent these exhibits to Miss I believe her name is Miss Mary.
Mm-hmm.
However, I attempted to reach out to Mr. Bernstein prior to things reaching this point, noting that things are escalating and becoming violent when I asked for nonviolent contact. There was a recent incident where I was in a public space and approached and harassed by Miss Kyle, during which I called law enforcement. And again, there's video of that was sent to Miss Mary. And being that Miss Kyle has already been arrested for battery against me and did not take that into account when we were in public, and took it upon herself to engage with me and my third party. I definitely feel like it is necessary to have a protective order in place.
And you prepared an affidavit, correct? For the change in the bond condition?
Did I prepare an affidavit?
Or you signed an affidavit?
I signed one during the battery case.
Right. That's what I'm asking.
Yes.
I'm looking at paragraph 4, and it says, I do not have any fear of Samantha harming me or my property. I would like to have a chance to speak with her and seek to repair our relationship. You do understand that one of the things that I have to take into consideration is whether you have a fear of being harmed by Ms. Kyle, and you've signed a document saying that, swearing that you don't have fear of her.
Yes, that was prior to her returning. And that was prior to me sending multiple text messages to Mr. Bernstein, informing him that these actions are actually beginning to escalate. And that I am now starting to become a bit fearful. I just assumed that being that she was incarcerated as a result, or was taken to jail as a result, that she would no longer engage in the same behavior. However, that was not the case.
Okay, so you do understand, Ms. Dean, that the purpose of this hearing is not to enter into protective orders because you may deem it to be convenient at a certain time, but then later you don't want it to take place. Because this is a heavy, heavy, heavy stick that you're asking for the judicial system to swing.
Yes, I'm not trying to go back against it. When I first signed that order, it was for non-violent contact. And I specified that I wanted non-violent contact. And when the contact became aggressive, it violated the order. And I informed Mr. Bernstein through text, again, which I sent to Miss Mary, informing him that things are getting aggressive.
Okay, I need you to explain it to me as if I'm a 2-year-old. What does getting aggressive mean? Like words, what actually happened?
So there was a time where I was outside and she slammed the screen door on my foot. I was refusing to engage in conversation with her about particular topics. And that resulted in items being thrown around. That resulted in...
Were the items thrown at you?
Yes.
Has she ever made a threat towards you for your safety?
She has made a threat saying that she is not afraid to go back to jail.
Okay. And what did you take that to mean?
That me calling the cops or trying to de-escalate the situation would not make a difference in her desire to get whatever revenge or whatever anger out against me.
How long were you and this Kyle in a relationship?
A year and a half.
And did you live together during that whole time?
Yes.
When did this relationship turn aggressive, as you stated?
The first few incidents began in, I would say, April. However, being naive and blind, I just assumed that things would eventually calm down, because after those moments, there would be conversations and both parties would apologize for getting the other person mad or reacting in a certain manner. So I was under the impression that things would be getting better versus worse. However, as the relationship continued, so did the arguments, so did the physical aggression,
Okay.
which then led into the battery case, which then led into asking for nonviolent contact, and then which led into now with the criminal trespassing case plus.
And there was a stay away provision put in place as it relates to the criminal trespass, correct?
Yes.
Okay. And you haven't sought to have that provision changed?
I was not aware that I could have that provision changed.
Well, you signed an affidavit in Exhibit 9 saying that you wanted the condition to be changed.
For the criminal trespassing?
No, not the criminal trespass, for the, I think it was battery or simple battery. I'll give you the case number. Case number 2021 WA13920. It was for an incident that occurred on July 27th of 2021.
Yes, I signed for no violent contact.
Okay. And then later, there was a criminal trespass. And was Ms. Kyle arrested again?
Yes.
And there was a stay away provision placed on that bond, to your knowledge?
Yes.
And you have not sought to have that condition changed or modified?
No.
Okay.
I wasn't aware that it could be modified. And I would still prefer that Ms. Kyle stays away.
Okay, so the reason I keep asking that question is because for the incident on July 27th of 2021, you signed an affidavit for that condition to be modified.
Yes.
And so now when I talk about the criminal trespass, you say that you were not aware that you could seek to have that condition modified.
Yes, I was contacted by Mr. Bernstein regarding the affidavit.
Right.
That's how I was aware of any type of modification that could occur.
Okay. So are there any other incidents of either threats or anything else? From Ms.
Other than
Kyle
what I
towards you?
say again?
I said from Ms. Kyle towards you.
Other than what I've submitted to Miss Mary, those would be the evidence that I submitted to Miss Mary, as well as the 2 cases on file.
Okay. Mr. Bernstein, do you have any questions of Ms. Dean?
Yes, Judge. Can you hear me okay?
Yes, sir.
Okay. Ms. Dean, since you signed the affidavit stating that you did not want to have any violent contact with Samantha, Samantha has not been arrested for putting her hands on you. Is that correct?
That's correct.
She was arrested because of a criminal trespass that I guess that occurred at y'all's jointly occupied apartment?
Correct.
At that time, when the police came out, you never told them that Samantha had laid her hands on you, correct?
No, she did not lay her hands on me. I did note to them that earlier that day, there was an incident during which law enforcement, East Point College Park law enforcement, were called, and multiple people had to keep her away from me. And again, I submitted that evidence to Miss Mary.
So the police were called earlier that day because Samantha called the police on you, correct?
I'm not aware.
You're not aware that Samantha called the police on you that day?
Are you referring to? I'm not sure if all of this happened in the one day, but yes, I do remember her calling law enforcement.
Okay. Now, you stated that you had texted me about Samantha, but you never texted me that Samantha had hit you or struck you or thrown anything at you, correct?
Incorrect. I sent you a screenshot and I texted you noting that she had slammed the door on my foot. And
You
that was
texted me, she also
afterward.
just, go ahead.
That was weeks after assigning the affidavit.
You texted me, she also just closed the door on my foot, right?
Yes.
Other than that, you never texted me that she hit you, correct?
I attempted to contact you, but you weren't available. And the next more conversation that we had, you noted that I would need to speak with an attorney.
Just the question I'm asking you is, did you ever text me that Samantha had hit you?
Yes, when she closed I texted you that she slammed the door on my foot.
I'm aware of that. That's not what I'm asking. Did you ever text me that Samantha had hit you or laid her hands on you in any way?
No, she
No.
used other items.
Okay. You never texted me that she threw anything at you, correct?
Correct.
In fact, the only quote unquote violent act you texted me about in these 6 to 7 months is that she closed the door on your foot, right?
I attempted to contact you multiple times via phone. And upon noticing that I was not actually going to receive any assistance from you as a result, I discontinued conversation.
I'm not asking if you called me. I'm just asking what you texted to me because you brought up reaching out to me. So the only quote unquote violent act you have texted me about is Samantha allegedly closed the door on your foot. Is that correct?
Yes.
Okay. Now, you have mentioned that Samantha was aggressive to you, but at no point during this 6 or 7 months did she lay her hands on you, correct?
She wasn't given the opportunity to because people blocked her.
These aren't trick questions. I'm just asking, during these 6 or 7 months, did she lay her hands on you?
She attempted to, but however, was she successful? No.
Okay, so the answer is no. Okay. Now, the two of you have been together for, you said, what, a year and a half, 2 years?
Mm-hmm. Correct.
Okay. Now, Judge, as far as my exhibits go, do you want me to show them to Ms. Dean, or I can't share the screen because we're on an iPad. I know the court could share the screen, or I could just put them in front of the camera. What would you like me to do?
What exhibit are you referring to?
The first exhibit I'm going to show is exhibit number 1.
And this is a photograph
Yes,
of a person with blood on their face.
that's correct, Judge.
And I'm assuming that is your client.
Yes, yes, Judge.
Ms. Dean, have you had an opportunity to see that photograph?
No.
Okay.
I have them all printed out. If you want me to just show it.
No, I mean, and that's fine. I'm gonna ask the relevance as it relates to Ms. Dean seeking a petition against your client.
Well, Judge, it's to show the actions that Ms. Dean has taken towards my client.
Which as far as as far as I'm concerned, Ms. Dean is the person that has the burden of proof here. Your
Sure.
client has no burden of proof. And so if she can't prove an act of family violence occurred, the petition is going to be dismissed.
Okay,
The fact that they're in a bad relationship, I take that as a given with every TPO.
understood, Judge. So Ms. Dean, just so I'm clear, because I haven't seen what you have sent, Ms. Moultrie, there's no pictures of injuries that you suffered at the hands of Samantha, correct?
Incorrect.
Okay. What
The
pictures?
injury,
You have
Go ahead.
pictures of injuries that you've suffered?
yes, I have multiple pictures of injuries that I've suffered. Which again, during the night of the battery case, the reason why she was arrested was due to the multiple injuries that I had. And additionally, I, yes, have sent in those images.
See, Judge, this is how my picture becomes relevant, because my picture is from this alleged battery, and my picture presents a case of self-defense. So I can leave it at that, or I can, dig into it.
You can leave it at that. As far as I'm concerned, the affidavit that was signed, in my opinion, negates whatever occurred or allegedly occurred in July of.
Understood, Judge. And I also wanted to point out, just in Exhibit 2, there also are pictures that demonstrate defensive wounds. But I will move on from that. If I can have a minute, Judge.
Yes.
You said that there are items that were thrown around. Any item that ever struck you?
Yes.
When did you tell the police that?
Yes, I also again sent in videos to Miss Mary, the judicial assistant. And in one of those videos, you actually see items striking me as I'm recording. And you clearly see Miss Kyle throwing those items.
I haven't seen them, Judge, but if you've seen them and they're not relevant, then I can move on. I mean, they haven't been introduced in evidence, so I can leave it at that. Is that fair to say, Judge? They haven't been introduced in evidence, so I can leave it at that?
Yes, sir.
Okay. And since there is a stay away order from can you give me the address where y'all used to live together?
Hold on, Mr. Bernstein. I don't allow that to happen since
That's fine. I'll rephrase it. The address that y'all used to live together, has Miss Kyle come back to that address to harass you or do anything like that?
No, she has not, because I have not been home.
Okay. And you haven't seen her since that incident where she was arrested for a criminal trespass?
She came one time the time that I saw her, she was accompanied by law enforcement.
Okay, other than that?
Other than that, no.
Okay.
And just so you know, Ms. Dean and Mr. Bernstein, Ms. Mary has not received any exhibits from Ms. Dean.
Gotcha. Judge, I don't think I have any more questions.
Okay. So, Ms. Dean, because you have the burden of proof here, before I even go over to Ms. Kyle, I have to make a determination that the evidence is sufficient for there to be even an attempt to respond. As I see the evidence so far, you and Ms. Kyle were in a tumultuous relationship that led to Ms. Kyle being arrested twice. you've stated that there was aggression, and that she made a threat of that she's not afraid to go back to jail. And you've testified that she has not come back around after this incident. With there being a stay away provision in place, I'm not concerned that you don't have protection if that's what you need. But at the same time, I've not heard any evidence at this point that would lead me to believe that a temporary protective or that the temporary protective order that was obtained ex parte should be continued. But I'm gonna give you one last time, and if you persuade me, then I'll let Mr. Bernstein put on his case.
Is there any way that I can attempt to resend the evidence that was sent to the judicial assistant?
So this has nothing to do with whatever exhibits or anything that was presented. I go on testimony as it relates to what has taken place, because things can be a one-off. Things can, you did something on one day. It could have been an accident, could have been all kind of things that come into play. But I'm listening for a pattern of harassing, intimidating behavior such that you are in fear of your life. That's what these petitions are for. They're not just so that people leave me alone.
So the pattern is usually once a case has come to a close or completely closed, then the behaviors start again. The aggressive walking up to me to aggress, the standing in a threatening position, the throwing items, the threats, as I've noted, I'm not afraid to go back to jail, or noting that she has multiple law enforcement friends. After she's done with a case, which is why I reached out to Mr. Bernstein after the affidavit, because once that was signed and completed, things calmed down until the case was completed, and then they revamped.
Okay. Let me explain something to you. Mr. Bernstein is representing Ms. Kyle's interest. He's not representing your interest. And so by reaching out to Mr. Bernstein, he's under no obligation to do anything for you. He only has one client, which is Ms. Kyle, and he has an ethical duty to do all that he can to protect her interests. So do you understand? Like it doesn't matter that he didn't return any phone calls or texts because he's not responsible to you.
Yes, I'm aware. I was just noting that was the pattern. And as a result of that pattern, I was noting the behavior that I engaged in, which was reaching out to Mr. Bernstein, who, yes, I am aware is not interested in representing me or my interests in the case, solely Ms. Kyle. However, I was just noting that upon completion of a case, once it is completed, the behaviors reintroduce themselves.
And so you understand that these petitions don't last forever. It's not like
yes,
a
I'm
wheel.
aware.
So if the problem is that once she's quote unquote not on paper, the actions arise again. She's on paper right now, correct? With the criminal trespass.
Correct.
Have you spoken to anybody from the solicitor's office about how you wish to proceed in that case?
No.
You should contact the solicitor's office. They have a whole office of victim advocates, and they'll speak to you about your concerns and things that you may have. But at this point, that appears to me to be the most appropriate manner in how to deal with this. So do you and Ms. Kyle live anywhere near each other?
Not anymore.
Okay. So Ms. Kyle, you should speak to your lawyer, Mr. Bernstein, about the best way for you not to be placed in these situations in the future. Ms. Dean, you have every right to feel safe and secure in everything that you do in life. But these proceedings are not here just so that people will leave each other alone. They're here because there is a verifiable threat that a person may be harmed, but for the intervention of the court system. And it sounds like you already have that in place with the bond condition placed on Ms. Kyle. Does that make sense to you, ma'am?
Yes, it makes sense.
Do you understand the steps that you need to take?
Yes.
Okay. Mr. Bernstein, I'm not going to require you to put on evidence because I haven't found that the threshold matter has been met. So I'm going to dismiss this petition for lack of probable cause. That an act of family violence has occurred.
Thank you, Your Honor. Does the order get mailed to the email to the participants, or how's the best way to retrieve that?
My understanding, go ahead, Ms. Mary.
I'm sorry, Judge. Once it is file stamped by the clerk's office, then I will email it to you, Mr. Bernstein, and to Ms. Dean.
Okay, thank you.
Okay. And once it gets file stamped, so hopefully we'll have it by tomorrow.
Okay. It's nice to put a face to your name. We have emailed a lot over COVID, and it's nice to finally put a face to your name.
Exactly, yes.
Okay, so both parties in this matter can be